Well, if we have nothing else but fun in this class, we do talk about all kinds of wild and crazy things, but this one is a little interesting too because it's not always what somebody wants to talk about. It's kind of like the life insurance part. We're talking about estate planning. That's the last cog in our perfect circle of covering all of life. Estate planning sometimes you think is meant for when you're older or the end stages of life. It is planning for that stage, but it is something you need to think about as we go along. So we'll cover all those things too. Um, an estate is anything that you own. That includes bank accounts, stocks, bonds, real estate, and personal property. So you can build an estate pretty quickly. So why would we do estate planning? What does that mean? Well, that means you're trying to figure out a plan to take care of the disposition of the property after you pass away. You may be trying to take care of the property while you're alive. We have living trusts and things to do that. Or you may be trying to figure out how to have everything sold and provide for income for something, to charities, to your loved ones, to schooling, whatever you have like that. So that's what estate planning is trying to plan how that goes. I call it our last bit of control from beyond that we can get in life because we can say how we want this to be taken care of. So it gives us that little edge of control when we're not here to control things. So essentially, estate planning has to do with having an estate, building your estate through savings, investments, insurance. You buy your home, you have those things, and then transferring your estate how you want it at death. And it can be to someone, it can be cash it all out and pay some charity, it can be don't pay anything to a dime to any of my family. I mean, you can set it up however you want. If you're married, it is nice to include your spouse and children if in your estate planning. You may not, and that's totally your choice. And remember, keep in mind, especially if you're a family or a large family, a death means a new lifestyle for your spouse. Now, that's not translated as they get a convertible and drive around town. They might, but it just means that you've had this joint income, you've had this joint life, and then all of a sudden, it's just them. It's kind of hard sometimes for some of them, and sometimes if you're the one that's taking care of all the money and everything in the house that deals with finances, and then you pass away, they're left not knowing where anything is. We've had quite a few clients through the years that's been the case. When they walk in, the spouse knows nothing about how the one that took care of all the stuff did everything. So it's, trying to get all that stuff set up too. And of course, if children survive you, figuring out how to pass it on to them. Your estate and things that you own pass to your spouse without any taxes or any issues. Usually it just goes straight to your spouse on most things. So it's not a huge issue then. The problem can come when both parents pass away and it's passing to kids because that's not considered a tax-free transition. So there may be taxes involved in some estate taxes stuff. So that's where some of the planning will come in too. If you've never married and you think it doesn't matter, I just have my dog and blah blah blah, you don't need to plan anything. I'm going to tell you that you probably need something in place, because if something happens to you, especially if okay, let's say you rent, you have a pet, you have a checking account, savings account, you have some charge cards, you have belongings, and you pass away. Your loved ones, whoever they are, will be the ones responsible for paying off your car, getting your apartment closed, um, selling all your goods or getting them sent to charity, however you want that done. And then if there's any estate taxes to pay, depending on where you fall, then they would have to take care of that. So that's where life insurance can come in to help with the expenses that they may incur in that time frame. I think I told you when I bought my first house, that's when I bought my first life insurance policy because I realized I was in a good neighborhood. My house would sell. I wasn't worried about that, except for the fact that I was leaving my mortgage payment to my parents, or if they were gone, to my brother to have to pay. And you think that's not really fair for them to have to pay it from their money until the house sells. I mean, they could, but it's just still one of those things where if you have life insurance, it takes care of that, and then they can, take care of it. They can either pay it off or they can make the payments with it, however. So it's that kind of thinking through things. You think, well, I'm just, who cares? Well, then you have your pet. Who's going to take care of your pet? If you have specific wishes, then you have to, you can lay those out in a will or in your estate planning also. If you don't name people and don't do that, then your estate goes to a judge. It's called you die intestate, which means you don't have an estate. And they assign somebody to take care of it, and they still have the same responsibilities. It just may, of course, not be handled the way you want it. So that's where it gives you that control beyond the grave if you set those things up. Um, so there's a lot of issues. Nearly half of marriages end in divorce, which means it can be difficult for spouses and adults to try to take care of estate planning. Um, if you're no longer if you're on good terms with your ex-spouse, it may make it easier, but if you have children together, it's going to make it tougher too, because of the fact that you may want to provide for your kids, but you don't want your ex-spouse to get it, or you want them to have your hands on their money, you don't want to leave stuff to them. There could be all these funny things that go on, so you just want to be sure, again, that it's set up for you the way you want to handle it, and it's going to be taken care of. Single parents, divorced or not, have to plan for their own death as a part of retirement and estate planning. If you're a single parent, you've got to think about, if something happens to me, who's taking care of the kids? Who's taking care of my checking account? Who's taking care of all this stuff? And you have to have specific things lined out in that. Um, Demands of daily living can keep people from thinking about it. Death is not something you want to think about. If you lose somebody near and dear to you, you think about it then and you think, I've got to get on this. I've got to do this. This is so important. And then life happens and you get busy and you don't think about it again until the next time that happens. So it's just kind of one of those things to kind of just think through all those things. Um, if you can plan those things while you're in good health, it really does help. So, they when you do a will, especially, they ask for sound mind, etc. They really want to know that you're in good thinking capacity. So you can do a handwritten will on your deathbed, and it'll have some clout, but you want to be sure you have it. If you can, be sure you have it set up the way you want to. You're going to have important papers. They'll have to have important papers. They may need a birth certificate, any marriage certificates, any legal name changes they need copies of, military service records, because there may be some military benefits they can apply for, Social Security documents. Are important to have, of course. Veteran documents, that falls under military service records, insurance policies, transfer records. If you had a bank account, exact how to get those. Safe deposit box, if you had that, where's the key? They sell a thing that you may have seen online called the knock box or Knox box. And it really does look like a really good way to jump into estate planning without having to sit down with an attorney and spend all this time. You still probably need a will, but you can go through all these things. But it just gives you a place to put, yeah, we have a storage building. We have we have two storage buildings, and we have keys. But we were always going, are these the keys or are these the keys? So it gives you a place to put those keys. It gives you a place to put lockbox keys. It gives you a place to put where the bank account is. It gives you a place to put what the bank account number is. And then it's all in one box or one folder, and it's ready to go. And like I said, you've heard me say through the other things, I have folders or 3-ring binders that I put that stuff in, but there's still stuff missing like keys. I have 2 key rings that are huge with keys, and one of them contains, and this is no lie, a skeleton key that unlocked the door at my grandfather's house. Well, I haven't gotten rid of it now because just because of the fact that it's a skeleton key and I enjoy that. But all I have to say, that's the only key on that keyring I know for sure what door it goes to. The rest of the keys on that keyring, I'm going, are these old? Are these our old house and our old cars? I think this is, but I'm not for sure, so I don't throw them away. This gives you, if you get one of these or if you do it on your own, gives you the place to put those keys in so you know what is actually a key. And those of you that are of the generation that you just tap your phone or type in a code don't understand having keys, but there are still keys for lock boxes, still keys for storage buildings. There may still be a key for your vehicle inside your, remote control thing. Your house may still have a key, or your parents' house may still have a key. So there's still some keys out there. So it just kind of gives you that. You'll need to know registration vehicles, automobiles, make sure you've got titles, payments, etc. So those are the papers you're going to need. Well, then you need a will. And a will is basically the declaration legally of the person's wishes of what happens to their property when they die. And then it transfers the property according to your wishes. Some state laws allow you to determine, some state laws, sorry, I talked about intestate. If you die without a will, then the state is going to be the one that's going to make those decisions. It goes to a judge, he appoints somebody, and you hope it's somebody that knows you and your family and et cetera, but sometimes it's not. So you want to be sure that they do that. And then they'll make the decisions on how your stuff is disposed of and paid and et cetera. Now, of course, charge cards and bank accounts and loans and all those things will have to be done, but then there may be some money left over. Well, what do you want done with that? So that's where that can come into play. Your will and testament will say, being of sound mind, memory, and body, I hereby publish, this is my last will, and it puts your name in there. I give my wife 1/3 of my possessions. I give my children the 2/3. I appoint my wife as guardian of my children. Again, not necessary, but always nice to have in place in case there's a discrepancy or somebody thinks somebody's not capable or something like that. If you don't think your spouse is capable, you can always name a brother or an aunt or whoever you think is capable. Um, then it goes through if you have to go to probate court, and then children have a right to demand and receive an accounting from my spouse when they get full legal age. When they have 18, they can withdraw the funds. You can set specific things in there. A lot of times when parents, especially if you meet with an attorney, they'll ask specific questions about your kids. Can you trust this kid? Is this the child you want to run it? Do you trust your son-in-law? I can remember they asked that question of my parents when they were setting up their will, because they put for power of attorney for medical things, um, myself first, then my brother, and then my husband. And the attorney went, "You trust your son-in-law?" And so, not everybody's trustworthy. Again, it gives you that responsibility to say those things and do those things. So, and then you can list in there if your spouse remarries, what there is that spouse entitled to anything, that new spouse, or is it just for your family that's primary, and name the people there. So, it gives you again some things to be able to do to specify how you want things taken care of. If your wife should predecease you and you have no parent for your kids, where do you want them to go? When we were young, my parents set up us to go to one aunt, my brother and I, and the money to go to the other aunt. Um, and looking back, that we laughed about the how that was set up, but they felt like that attorney that they met with said that it was nice not to have kids and money with the same person, because then that gave accountability. The aunt that had us had to explain why she needed money. The aunt that had the money had to explain why she was getting it to the kids. So, it kind of gave accountability for both sides, not just one aunt gets, hey, the kids and the money, because if it's not the right person, they could spend all the money and the kids still don't get it. So, it's just those things you have to think through family dynamics. And I will tell you, working a lot of years in the trust department, I don't know everything about a trust for sure, but I did witness a lot of families coming in as one big happy family until someone died, and then they turned into the Hatfields and the McCoys. I mean, there were people sneaking up backstairs, trying to get in first to a meeting to tell you that relative was crazy, and they're going to come in and say that they need to do this, and they're off their rocker, and then that person would come in and say, no, that person's off their rocker. I mean, it was just, the dynamics would change dramatically. Sometimes I'd go, was that the same family that came in here all happy, all of them together? And, so it's just weird what money does to people sometimes. And then, of course, you have to worry about tax laws. There's federal laws that you have to worry about, but there's also state laws. And so you want to be sure that you have those covered in your will. If you change states a lot, or you change states, period, you want to make sure your will holds up. It would hold up federally, but does it hold up in that with that state's laws? Because sometimes they may have an extra caveat in there you need to include. Um, and then you date it, sign it, etc., and then there you go. If you marry after you've had a will, the will can be revoked automatically unless certain conditions are met. Um, if you divorce, you want to be sure you go over it with your attorney and make sure that if something happens, that there's not something that revokes that will. Divorce is not necessarily the caveat that revokes that will. So you want to be sure you have that covered too. And sometimes things change. You think, I want to leave everything to this sibling because they take care of everything really well. And then, years later you find out how they have a gambling problem, or they have a drug problem, or they can't manage money at all, and you may change your mind. Well, there's things you can do, and you can tack on what they call a codicil. You don't have to rewrite the whole will, you just tack on a new page. Okay, I wrote this in June of, 2026, but now in May of 2028, I need to change that with these 3 items or something, and they can do that without having to redraft the whole thing, which is easier. A simple will would give everything to your spouse. A marital share will leave half of it to this spouse and to the children as heirs. An exemption will, trust will, um, leaves everything to your spouse except for the amount equal to the exemption, which then passes to the trust. So, what's an exemption? Well, it's kind of like when you think of your taxes. They give you a dollar amount that you're exempted from that you don't have to pay taxes on. They have the same thing with estates and with wills. And so, if you have a large estate, you may want to take the part that's exempt and put it somewhere, and then pass the rest to a spouse. You could do that and split it up. Used to be the exemption level was pretty low. It's now pretty high. And when it was pretty low, a lot of people met it very quickly. So that kind of decision was really important because of the fact that you didn't want to necessarily give this big, huge taxable event to everybody just because you happen to have a car and a house. It was at $1 million. You have a car and a house, two cars and a house. The house full of stuff. You might have a pool, you might have a boat, and all of a sudden you're at $1 million. I mean, when you pass away, that's what those things are worth. So, if it was $1,500,000, you might want 500,000 of that. That is over the exemption to pass to your spouse because then there's no tax on it, and then the other part to be put in an exemption trust or something so it's not taxable either, to avoid having to pay 50% tax on any amount that's over the exempted amount. You can do specific dollars to everybody. You now can do a holographic will that you write, date, and sign entirely in your handwriting. Um, there was a murder mystery with somebody that had done a holographic will, I think. But anyway, it's not legal in all states. You want to be sure if you do something like that that it's legal. Then of course there can be a formal will that you drop in an attorney's office. The thing about it, you must have it signed by two witnesses that neither one are beneficiaries of the will. So usually, like if you're in your attorney's office, they'll bring in their secretaries. They're not benefiting from your will at all. You sign it, they sign it, and then you're good to go. If you're doing this at your on your own at home, you can do that. But just be sure that when you do that, that you bring in two people that aren't in the will or getting a benefit from the will. So maybe get neighbors or the DoorDash driver or something that you could pay a little extra to witness that, because that's you want to be sure it holds up in court, and that's where that would come into play. Um, Again, because we're looking at what we want to have, like we do when we look at retirement planning, we're looking at what we want to have for our estate plan. Estate plan fix it. This is not. I'm not able to say that word. Fits into our retirement planning because it's part of our planning for our retirement. We're planning for the our death and how the retirement will continue on. Um, but when you do that, you need to know where you stand. So you need to have a list of your assets and liabilities. You need to know what your net worth is. Now there may be things that you buy after that. A lot of times people will draft a will when they have their first child. A good way to list that then is and any child born of this marriage. So that then there's a caveat in there in case you have another child and don't get in time to update the will or forget to update the will, because people are notorious for getting a will, and especially when lockboxes were the thing. They put it in their lockbox and, of course, forget they even had it until somebody died. You found a key and you went, this looks like a bank lockbox key. And you'd go from bank to bank to bank, seeing if it was their key. You'd find it and you'd find the will, and, only listed one child and they had seven, or something. And so putting a caveat in there, and attorneys will do that, and any other children born of this marriage kind of covers that so that you don't leave the other kids out. And then, of course, you need to evaluate your planned retirement income. Do you have something that all of it stops at your death, or is it continuing on to your spouse? So then that lets them know what that's going to be done, and having that. If you're working part time, you need to be sure that you list if there's any benefits where you're working. Sometimes there may be added life insurance or group health or something, group life that they're doing there. So just, be sure you do that. Um, so based on this, the Economic Recovery Tax Act of 1981 had many experts that advocated the traditional marital share will. And what that means is that they just basically went through trying to figure out the size of your estate, how it would share, and how it would share to your spouse. And again, like I said, it'll pass to your spouse without without any or very little taxable event. It's when both spouses are dead and it goes to the children that there could be a big taxable event. So that may be when you want to be sure to evaluate that, because you want to be sure to take in inflation. You want to be sure you have the ages of you and your spouse and have that calculated into that. Cash on hand you need to have when you're looking at that. Because they may need to get cash quickly, maybe put some kids on the checking account so they can get into the checking account quickly to pay some bills that come out before you can sell the house, sell the truck, sell the car, and get the estate settled. When you write your will, select an executor. This is the person that's going to follow your instructions. I would ask you to please notify that person that you've named them as executor. We had somebody name me as an executor, and while it was a huge honor, it was a huge shock. And so it's taken me a little while to get my head wrapped around exactly what my duties are in that, because I had not planned on that. So I would just say, please let them know that you did that. And then find out, because you want to find out if they're willing and able to carry on the completed tasks. I didn't know anything about it, like I said, till she passed away and the attorney called. And then, make sure that it's not somebody who's convicted of a felony. That can get your will null and voided. And of course, you can't. Sometimes somebody is fine when you set up the will, and then something happens later on, so there could be a problem there. But anyway, they can be a family member, they can be a friend, they can be an attorney, they can be a bank, they can be an accountant. It doesn't have to be, a specific person. It's just who you think will carry on your will and do it. If you don't have one, the court will name one, and that's where you want to try to avoid that. Executor's fees are set by state law. Um, the executor needs to provide an inventory of assets. They need to collect any money due and pay off any debts. They need to prepare and file all income and estate tax returns. They may have to hire a CPA to do that. They need to liquidate and reinvest other assets to pay any claims and get them set up in the trust to invest from that. They need to distribute assets based on the will. The will may say pay everything out right away. It may say pay everything out over 10 years. It may say keep everything as you can, and pay out a salary. It'll tell you. And then make a final accounting to the beneficiaries, and to the probate court. So the major responsibilities are to take advantage of the assets, not take advantage, take into account the assets, sell stocks, sell bonds, get cash, take over checking accounts, etc. And then get things set up under the trust. It should have a trust ID number, and then it will take care of itself, and then provide accountings thereon. When you write your will, if you have children, you want to put a guardian or who you trust to take care of your children. This person will accept the responsibility of providing care for your kids. So you want to make sure it's somebody you trust, somebody you agree with, and that may change. You may change your guardian through the years. So you might, that may be what you add as a codicil to your trust sometimes, because that can change who you want to take care of your children. And then you see them with their kids, then you go, no, I don't think so, um, or they don't have kids, or they're never home, or just whatever. You can make that decision. A trustee is a person or an institution or a bank that holds and manages the property for someone else. So you may under the trust agreement. So if you have a will and then you set up a trust, then that person is the trustee and takes care of that. If you want to alter or rewrite your will, you need to if you move to different states. Again, like I said, federal law is the same for all, but state laws may change. If you've sold property that's specifically listed in the will, if you haven't listed personal home living in, you may need to update your will to say the house is no longer on Elm Street, it's now on Maple Street or whatever. If the size of your estate changes drastically, you win the lottery, you might need to change your will. If you've married, divorced, remarried, you might need to change it. If other heirs have been born, died, that could make a difference too. Again, you don't have to change it all the time, but you do have to keep up with it. And then, like I said, you could add what they call a codicil, and just add. It's just like a piece of paper or two pieces, however many changes you're needing to do. And it just says the will's in effect, but these changes have taken place on page 2. We now have 2 siblings. On page 4, this person passed away, and on page 5, we no longer leave the kids to XYZ. And then you just add it to that. Prenuptial agreement. You may or may not have a prenuptial agreement. That can be part of your estate planning too. You can spell out in that how things will happen and what will happen upon disposition of your marriage. It can be. Those are those are in a lot of murder movies for sure. You can tell I watch murder movies, don't you? But anyway, They will, specify maybe dollar amounts that are given. If you leave on your own account, you get nothing. If you leave because I died, you get this. If you stay 20 years, you get this. If you stay 5 years, you get this. Whatever. You can, I mean, those are between you and the person you're getting married to. That has nothing to do with it. But those can be done, and I would recommend you get those with an attorney. You can have a living will, which basically means if you become physically or mentally disabled, someone can help you. It doesn't substitute the traditional will, so it's not when you die. It's just if you're still alive, living is the big key to that sentence. Um, and so it just tells how you'd want to be taken care of. You'd have to sign and date it before a couple of witnesses also, and then give copies of people that are close to you. And so it just kind of says how you want to handle those things. And let the doctors, and they'll ask at the hospital every time you have surgery, do you have a living will? Do you have an advance directive? Is someone here going to make decisions upon your... You don't have to have it before every surgery, and I can promise you that because I've had a few that have been surprise surgeries through the years. But it is something. Usually, if you're married, you can just say it's my spouse. I don't have one, but they'll be the ones making the decisions, that kind of thing. If you're single, you might rethink it or make sure your parents are there with you, or say no, it has to be my mom, my dad make stupid decisions or whatever. You just want to make sure it's somebody that knows you and makes the right decisions. You can have a healthcare proxy, which is also called a durable power of attorney, which basically means if I need health care, here's who you talk to, and this person can make decisions. And if I'm incapacitated from health care, this person can make decisions based on, you can specify your house payments, your car payments, whatever, and your health decisions. You can specify just your health decisions, or you can specify that they have a power of attorney if you're incapacitated because of health, and only for the things that are day-to-day expenses. There can be a letter of last instruction. I want my funeral to be X. I want this to be played. I want this to be done. I want this, whatever. That's what they call after death wishes. So that's, again, a little extra control you can have there. But you might put in there what you think of as a funeral, what you don't want as a funeral, that kind of thing. Sometimes, kind of like when you go to weddings, you think, I don't think I want that. There can be an ethical will. That means it's a document that dispenses emotional and spiritual wealth to the heirs. So it's a way to pass on your values and beliefs to your heirs. It's not a legally binding document. It can share lessons that you've learned in life. It may be, you may decide to record it, and just talk to them about, whatever. It requires you to have self-examination, and it also means that the writer and the recipients that get it say it's an invaluable legacy, an invaluable life lesson. Sometimes, especially with grandparents, or an aunt and uncle that live far away that you may not be around a lot, sometimes you'll find these ethical wills in that they'll just leave a note, a written note, or now they'd probably do a video. It just kind of says, hey, we haven't talked about these things, but I just want you to know I've faced a lot of challenges in life, and this is how I got through them and what I did, and, this kind of thing. And it kind of gives their history. And kind of like on, if anybody's on Ancestry and all of a sudden you find, their World War One draft card, and you're like, we found one for one of my dad's aunts who they didn't talk about much. We found out she ran a whole hospital, but she was single, and it was like in the late 1800s. He was one of her great aunts. But anyway, we said, well, that's why they didn't talk about her, because she was some wild lady running a hospital by herself. But that was a fascinating thing to find out. And so, a lot of times families don't talk about those things. And so it's just, this is a way that you could talk about those things. A social media will. Now that has become extremely important. Um, some of the social media sites will ask, do you want to name somebody to handle your account should you die? So that's one step in that. But the other thing is, how do you want to handle, I mean, if you've got X, Twitter, now X, Instagram, Pinterest, Facebook, Threads, Blue Sky, or I heard somebody the other day call it Blue Ski. I made me crack up. If you've got all these accounts, well, number one, you've got logins. Number two, you've got stuff that's out there. And if you're a poster, and you have stuff that's out there that you've taken care of, taking the time to post, you may want somebody to take that stuff down. You may want to have some of that stuff archived. So this is where you could describe that and discuss that. Who do you want to handle it? How do you want them to handle it? Do you want them to shut down your account? Do you want them to create a legacy account where people can still come and go, oh, I miss you so much, and put that on there for health purposes? And a lot of times you'll find, especially on some of these accounts, when someone has passed away, like Facebook, they didn't have a legacy person set up. They didn't have a social media account set up for it. They don't know how to log into it to shut it down. You have to contact them to shut it down. Anyway, it can be a real big, hairy process at prove who you are. And, because otherwise anybody could call and say, hey, shut this account down. So again, if you're heading into social media, if you have a TikTok account and you're selling stuff on TikTok and all this stuff, you might want to check into having some kind of a social media will of how that stuff is handled, if something should happen to you. And then you provide the list of all the websites you're on, the profiles, username, password, etc. So all those things can be important. There's also, we talked about a durable power of attorney or a healthcare proxy. Basically, someone can act on your behalf if something should happen with your health. It can be limited, this surgery on XYZ date, or it can be a general power. It can be regardless of health and healthcare and home. So anyway, you can make all those decisions when you make that up, but that's what that would be called. Your letter of last instruction, we talked about that. You can put all the stuffs in there that you want. Um, Trusts and estates, what kind are there? Well, the trust is considered a property arrangement where a person, bank, that's called a trustee, holds the title to. So they become the owner of your house, the owner of your car, the owner of all these things. Now, when you've passed away, you won't care about that. If you have a living trust or a living will, that you might care that they own it, because then you have to go to them to get the things released if you want to buy or sell. It's used to protect assets from creditors, etc. So when you start getting large estates or a large amount of money, and if you're in a business where somebody could sue you, you might set up a trust, a living trust, and put all your things in it, because then they can't sue you for your home. So those things can make a difference depending on when you hit those things. And some never have a living trust or a living estate, just because it's not needed. They just set up for one for when they pass away. You can make them revocable or irrevocable. Revocable means you can change it. Irrevocable means you can't change it. And both come with different tax liabilities and limits and credits. Irrevocable trusts were set up a lot of times so that nobody had any contact with it. Once you set up the trust, your decisions were kind of set in stone. Now you can, with an attorney, do something and have everybody that's supposed to profit from that trust sign off on it and change it. But it was a big deal. Revocable trust gives you the option to set things up, but then you can go in and change them, and you can change the items in there and etc. Irrevocable trusts were used a lot with life insurance trusts, because the life insurance policy was going to be paid. The life insurance policy paid to the trust. They had no choice over it being paid, not paid. The trust paid it. It was just an asset. And again, that was a lot of life insurance was sold when the tax rate was a lot lower, so that gave you something to pay the taxes for your estate on, that came to you tax free, tax free. But insurance money passes to you as tax free money, so it goes to your beneficiaries as tax free, or your trust as tax free. So that was done that way. And then in an irrevocable trust, it becomes a separate entity, a separate tax entity. It's not your trust. It's the, Robin Guadagnini irrevocable trust. And irrevocable is in the title, always, to let people know that that's how it was set up. And it just means that, again, those assets aren't mine. They're the trust's. So if someone tried to sue you, they're not yours, they're the trust. If you wanted to sell something, I have to go through the trust to sell it, because it's not mine, it's the trust's. And it works for tax purposes too, because I don't own it, so I don't have to pay taxes on it, because the trust owns it. So it can be used in a lot of ways. And revocable just means I can change it, I can say who gets what, and I can keep changing my mind. And so there's not as many tax, quote unquote, perks with the revocable trust, but there still are perks. So you want to be sure which one works for you. If you establish a trust, it's going to free you from managing your assets. You don't have to, keep up with them. Someone else is. A trustee is. You're paying a fee for that, but a trustee is keeping up with it. And then again, it provides income for surviving spouse or your beneficiaries without you, again, having to specify a lot of things. It'll avoid probate. It immediately transfers your assets to the beneficiaries. It takes care of it. The trust is set up. All the documents have been done. They know exactly what to do when you pass away. Those things all kick into high gear and it's taken care of. So there can be a credit sheltered trust, which is called a bypass trust. There's so many different names, and I apologize for that because it's all Greek, I know. Um, but they also might call it an AB trust, and basically what it means, it's a family trust, and it's done uh, to bypass credit. But anyway, just think of it as credit shelter. You're sheltering your credit. Um, so it's basically something that's going to pass on and not be a taxable event to the person it's passing from to. A disclaimer trust, that means you don't have enough assets necessarily to use the credit shelter trust where you're trying to shelter all your assets, but you may need one in the future. So you can set up the little trust first and then it becomes the bigger trust. And then of course we talked about a living trust or living will, that can happen. Those again are property management while you're alive, so that gives you um, the option to have those. I loved that the other name to call the living trust, which I hadn't heard this until this class, to be totally honest, was inter vivos. So I'm not going to ask you that on the test, I promise. But just I thought that was an interesting way to call that. Testamentary trust means there's no trust set up, and it's set up by your will. And so your will says, when I die, all this stuff goes into the trust, and then it's distributed this way. And that's when that's set up. So that's called a testamentary trust. Life insurance trust, we talked about that. It's set up where life insurance proceeds get paid into it, and then they either get paid out to the beneficiaries, they pay the taxes. Typically, they pay the taxes first and then pay to the beneficiaries. But anyway, at least part of the proceeds are from your life insurance trust. To figure out if you need an estate or when you set up an estate, list everything: cash, checking account, savings account, CDs. We talked about that. Stocks, bonds, mutual funds. And you not only want to list them, but you want to have your sign ins, your passwords, your account numbers. You want to have all that stuff on there. Again, maybe looking online and getting something that makes you have a form to fill out might help to be sure you've covered everything. Life insurance you want to list. You may have employee benefits at work. You may have a disability policy. They may have a life policy on you. You may have bought a life policy when your buddy went into the life insurance business 20 years ago and you paid a single premium and you forgot all about it. You need to know about that too. So you've got to make sure you list all those things, because trust me with your trust. Trust me, we've had clients come in and go, we found this policy. Is this even in force? And, we're happy to try to find and see if it is. But a lot of times, probably half the time they are and half the time they aren't. They quit paying the premiums but they didn't throw the policy away. So, it's just easier if you can keep up with all that and your loved ones know where they're coming from on that. Of course, if you have a farm, list all that. You're going to have grain, you're going to have livestock, you're going to have machinery, you're going to have equipment. If you run a business, you may have stock, partnership, proprietorship, etc. that you have to do. Any notes, if you've loaned money to anybody and had a loan, any loans you're paying, and you have those on file. Accounts, if there's claims receivable, depending on your business, you may have some outstanding debt. Where is that? Who is it? Who owns it? And then keep all that stuff together. Antique, work of art, collectibles. You may have things you don't care if they sell, and you may have things you care if they sell. So you want to be sure you have those things spelled out too. Community property is defined as anything that's been acquired during a marriage, but not by gift, by bequest, or by inheritance. We've had people, when they've inherited money, they get a divorce, their spouse sues for half of that inheritance. They can't. That's not community property. That was an inheritance gift directly to their spouse from their aunt, uncle, whoever. So that's not considered community property. Community property is what you divvy up on an estate. But those kind of things are not considered community property. So you want to avoid taxable estate if you can. Like I said, right now I think it's 2.65 million. Anything over that is taxable. So, and they have only increased that in the last few years. They may go back to it being lower, but I don't really see that, because the states have gotten huge, of course, because everyone kind of has so much more money. But taxable estates could include, of course, real estate, Annuities could be, they could also be community properties. They could pass to your spouse without being taxable. That's what you want to keep in mind. But then you want to avoid irrevocable life insurance policies or annual exclusion gifts. Um, I'm sorry, you don't want to avoid them. You can use them. There is you can tell your parents when you're home after class that they can give you a gift each year, up to, I know it's been 10,000. I think it's a little higher than that per parent to each child, and that helps reduce their estate. You get that tax free, and they can do that every year. So you can tell them you're a wonderful gift, and they need to share that with you. And what that does is that helps reduce your estate taxes if you start getting high, because you can see a taxable estate is going to include property, cars, checking accounts, annuities, investments, IRAs, retirement plans. All those things are added up. So that can be quite a sizable estate pretty quickly. If they reduce it by giving you some gifts and exclusions to the gift exclusions through the year, that helps reduce that. You can have joint ownership on property. You can have joint tenants with right of survivorship, which means that it passes directly to your spouse upon your death. Estate tax is paid when the surviving spouse dies. That's how most things are set up. Just so you know, they may abbreviate it as a WROS, which means it's a right of survivorship. Um, they could be tenants in common, which means they each own a proportionate share. They could be tenants by entirety. And that was when one spouse dies, the other gets the property automatically and they get all of it. So it's not ever split or anything like that. So those are just a couple ways you could have ownership spelled out. Life insurance and employee benefits, we've talked about how those are taxed, etc. Lifetime gifts, again, they can reduce their estate. They can give you money, so tell them you'd love to take part in that for them. Um, but it is kind of a nice perk for sure. And sometimes they'll do that. They'll use that if they're going to help you with a down payment on a house or something like that. So, and there is a lifetime limit, but I think it's in the millions of dollars. So it's usually most people don't hit that on their lifetime. Um, Settling your estate, so you want to make sure that you've got everything that will take care of it. You need a will. You may need a trust. You're going to need an executor. So you just make sure that you've got those things lined out. If you don't have a will, as I said, it becomes what they call you've died intestate, which means you don't have an estate. And it's put under the control of a court-appointed administrator who will take care of it. They go through the same process as the one we've talked about, but it's just court appointed, and they will try to figure out your best wishes, of course, but they won't know exactly how you want to do it. Something else to keep in mind when you look at taxes, this has a whole nother realm of taxes. There are estate taxes if it's over the amount dollars that the IRS has listed for that year. There can be estate taxes and state federal taxes. Some states charge estate taxes irregardless of whether it's over a dollar amount or not. There are some federal income taxes if it's under a dollar amount, but there are some things sold that created an income that maybe hasn't been taxed before. There can be inheritance taxes depending on who you are and where you fall into the chain of things being inherited. There may be an inheritance tax to pay, and then there's gift taxes if it's over the amount allowed each year. So just keep in mind that those can add up too. And again, always we want to avoid taxes. We don't want to evade taxes. Here's the tax rate in 2001. You can see how it went up from 2001 to 2013 was as high as this table went. But it tells what the interest rates, the highest estate tax rate first, and then the gift exemption tax was in the millions, then the state exemption, then the gift tax, and then the note. So you can read that on your own. It's not necessary for anything that we're discussing. Just lets you know where taxes have fallen in the years and how things are being taxed. And then it goes all the way to 2024. Okay, that's all I have. I know that's confusing as heck. I know it's stuff you don't really want to hear about because it's like, stuff when you're like later on in life, but I hope it provided some insight, some knowledge, and some wisdom. And I appreciate your time. And if you have any questions, of course, let me know.